certainly not disrespect anyone's view of what decision they make in relation to this bill.
No, Margaret. Senator Van Turnhout, 10 minutes.
Welcome, Minister, to the House. Cahirlock colleagues. I welcome the opportunity to share my deliberations on the protection of life during pregnancy bill. As a member of the Joint Oireachtas Committee on Health and Children, I attended the 6 days of hearings around this bill. Over 3 days in January, we discussed the implementation of the government decision following the expert group report, and over an additional 3 days in May, we considered the heads of the bill that is before us today. The hearings provided a forum to discuss the legal, medical and ethical issues relevant to the bill, and we heard from experts often espousing very contrary views from each of these disciplines. I fully support the government's decision to legislate to implement Article 43.3 as interpreted by the Supreme Court in the X case. However, I do have concerns in relation to the bill before us. The principal point of contention in this bill has undoubtedly been Section 9, risk of loss of life from suicide. Suicide in pregnancy is real, it is a real risk to the life of a pregnant woman, and it does happen. I am very concerned about us drawing a legal distinction between a risk of loss of life emanating from a physical or a mental health condition. There is no such distinction enumerated in Article 40.33, nor any distinction made by the majority of the Supreme Court in X. I feel that separating out physical and mental health in the wider public debate on mental health and efforts to destigmatise mental health illness is a regrettable and retrograde step. I fully endorse and agree with Senator John Gilroy, who spoke yesterday on this issue. During the hearings and in my own research, I've encountered conflicting legal reasoning and argument around the suicide question. However, I remain unconvinced of any need to distinguish between the manner through which a risk of loss of life manifests, and I note in this regard the conclusion of the expert group that a differentiated treatment does not appear to be required for medical or practical reasons. It is strongly my view that Sections 7 and 9 should have been merged. Can I remind colleagues of some of the examples we heard about how suicide can and does manifest in pregnancy during the hearings, such as a woman with an eating disorder who has already taken 3 overdoses in the course of her pregnancy because she cannot deal with the additional stress of the pregnancy on top of her psychological disorder. A woman who is pregnant as a result of paternal incest. A woman who is in an abusive relationship in which the level of physical violence and abuse has increased during the pregnancy. She is trapped, frightened for her safety and suicidal. Many contributors to this debate have stressed their belief that abortion is never a treatment for suicide. I refer to Dr. Anthony McCarthy in this regard, who rightly points out abortion is never a treatment for suicide, but neither is counselling, psychotherapy, antidepressants or anything else. There is no treatment for suicide. Over the past few weeks, we've heard much use of the term conscience, which is a person's moral sense of right and wrong, viewed as acting as a guide to one's behaviour. I would like to assure the House that in each and every decision I take as Senator, I apply my conscience. I did so when I voted against cuts to respite care, blanket cuts to child benefit, cuts to disability services and targeting of lone parents in successive budgets. I do not reserve my conscience to be used only for specific pieces of legislation. I would certainly like to see greater consistency on children's rights issues in these houses in the future. Throughout this debate, the term pro-life is frequently used as a calling card to identify opponents to this bill. I really object to this terminology and its connotation. In supporting the bill, is the upshot that I'm not pro-life? Because let me assure you, I'm absolutely pro-life, both of babies and women alike. Also on this point, I'd like to note that a delegation of so-called pro-life senators and TDs went on a search for truth trip to the US earlier this year. I believe others have gone on previous occasions. This trip was apparently funded by the Family and Life organisation, which according to its own website is opposed to the MMR vaccine. They suggest as an alternative that we wait for the development of a product that is outside the current limits of science. The MMR vaccine has been proven to save lives. I find it reprehensible that any member of the Oireachtas could be purported to be pro-life and yet associated with an organisation that is against the HSE vaccination policy. This policy is about saving lives. I call on senators that availed of funding for this trip to clearly state on the record of the House if they support the HSE's vaccination policy. Minister, I'm extremely concerned about the scope and potential application of Section 22. I think the penalty is too severe and the scope of the provision is too broad. The penalty of 14 years in prison and an unlimited fine is an extraordinarily onerous sanction. Presumably, 14 years is anticipated to be the starting point for a judge in deciding what sentence to impose in the event of a successful prosecution, which will be drawn down from on the basis of mitigating factors and circumstances. Furthermore, some 152 years after its enactment, we will ensure that the chilling effect of Sections 58 and 59 of the Offences Against the Person Act is carried forward into this bill. Is this really what we want to be doing? I was struck by the hypothetical but potentially very real scenarios of young girls sourcing anti-borsiflazine tablets over the internet put forward by several TDs in the Dáil. I find it very hard to envisage that any court would see fit to sentence a 15-year-old child to 14 years imprisonment for bringing about the termination of an unwanted pregnancy. This would fly in the face of the sentencing principle of giving light at the end of the tunnel. It's highly unlikely to act as a deterrent given the lack of reason and rational thinking a terrified 15-year-old pregnant girl is likely to be capable of making, and is not justified as a means of protecting society. So why are we, as legislators, putting it forward? Let's be honest, it's a way of appeasing people who are opposed to the bill. Those who would be opposed to the bill, no matter how it is drafted, because they are fundamentally opposed to the principle. It says to them, don't worry, if anyone deviates from the strict limits set out in this law, we will bear down on them with an iron fist. But this is no way to determine an appropriate sentence for a transgression of a law around such a complex issue involving potentially vulnerable, scared and desperate women and girls. It is barbaric. If the potential imposition of a custodial sentence longer than that applied to most rape, incest and violent sexual assault cases and many murder and manslaughter cases was what was needed to allow some members to support this bill, I'm disappointed. Furthermore, it's potentially very dangerous, as women and girls who have taken abortifacients and who develop serious life-threatening complications will be extremely unlikely to seek timely medical advice in the face of a 14-year prison sentence. Are we really purporting to introduce a law entitled Protection of Life During Pregnancy that by its own sanctions may put women and girls' lives at risk? And the last area I'd like to address, Minister, is that I'm concerned about the silence in the proposed legislation on children, particularly young girls. If we look at the X, C and D cases, they involve children under the age of 16 or children in state care. This bill is silent on the complex issue of consent for minors for access to medical treatment. This bill does not distinguish between a woman over the age of 18, who has the right to refuse or consent to medical treatment, and underage girls for whom there is no clear laws governing issues of capacity and consent. I cannot imagine the unbearable situation of a child who has been raped by someone they trusted, is now pregnant and is in the care of the state. Parents will normally be asked to give their consent to medical treatment on their child's behalf. The law is unclear with regard to under 16s, who should they seek access to medical treatment without their parents' knowledge or permission. We must remember that consent also includes the right to refuse. We continue to bury our heads in the sand when it comes to the scenario that I've outlined, which, whilst unimaginable, has and does occur in Ireland. We are uncomfortable facing up to this reality and dealing with it appropriately, but we have a responsibility as legislators not to compound the voicelessness of children in the care of the state in this legislation. I believe we need distinct legislation to clarify the issues of capacity and consent where the patient is under the age of 16 years of age. After careful consideration and much thought, and despite the concerns I've raised, I can support the Government's decision to legislate as proposed in the Protection of Life During Pregnancy Bill. The reality is that this bill only deals with rare and complex circumstances. As some fear and have resisted, this legislation will be the starting point of a wider public and political debate in the future, one that considers what others have argued 21 years on from the X case ruling are actually the contemporary issues that should be central to the present debate, such as fatal fetal abnormalities, pregnancy as a result of rape and incest, and wider reproductive health considerations. These issues will throw the spotlight on the 8th Amendment of the Constitution, and the people will no doubt be called upon to inform government of their wishes through a referendum. This is the beauty of a popular sovereignty. The will of the people will win out and will inform the legislator on the changes, if any are required, to our legal arrangements. Debate around social change is to be welcomed and embraced if we are to evolve and grow as a society. Thank you.
Senator Seanad, 10 minutes.
Good morning, and I welcome the Minister, of course.